So, Mr. Thomas, there had been a objection to the change the notice of disqualification that had been filed. There had been a number, I believe 2 different notices of disqualification that had been filed. In Lewis County, citing to the Lamon versus Butler case, that's L-A-M-O-N versus Butler at 112 Washington 2D 193, a 1989 case, states that that case stands for the proposition that there is not a right to multiple notices of disqualification. So what's your position regarding that objection?
So the plaintiffs have a couple of different arguments about that. First of all, the objection isn't timely. Blumstrom versus Tripp, which is a Washington Supreme Court case in 2017, states that the purpose of requiring an objection is to apprise the court of the claimed error at a time when the court has an opportunity to correct that error. The court doesn't have an opportunity to correct the error because it's already been changed.
Well, I would just tell you, Mr. Thomas, I'll just be direct with you. There's no reason the court can't correct that. There's no reason the court cannot invalidate the notice of disqualification that had been the last in time, which was, I believe, Mr. Is it Hupy or Hupy?
Hupy.
Mr. Hupy. It could simply be invalidated, and then the case would be reassigned back to Judge Schaller properly. So my issue is more, do you have an issue as to the merits of whether, in fact, Lamon v. Butler does not cover this situation?
I don't think that defendants can make an objection when they weren't a party to the lawsuit. So they weren't a party to the lawsuit until they filed an answer. This court has rules about appearances, and in Morin v. Burris, a Washington Supreme Court case in 2007, says that parties must take some action acknowledging that the dispute is in court before they are entitled notice to a default hearing. But anyway, it talks about what an appearance is, and they actually have to make some sort of formal action in court. If this court looks at the transcript, Mr. Eisenberg last week did appear in court for this case, but he didn't even know what the case was about. Neither did the court, and so that's why it was postponed this week. It begs to reason how Lewis County or Mr. Eisenberg could make an appearance, a formal appearance on the record, when he doesn't even know the substance of the case or what the case is about. And so if he doesn't know what the case is about, then his appearance would be with the answer, and it begs to reason to this court how you can make an objection to something that you weren't even a party to at the time.
Mr. Thomas, again, I'm going to ask you specifically, do you believe that you have the ability on behalf of your clients to file multiple notices of disqualification? This is an issue that at 412050, I'm not really concerned about Mr. Eisenberg, quite frankly, in this equation. I'm curious your argument as to whether or not there is the ability for your clients in regards to this case, whether they have a lawful ability to file multiple notices of disqualification.
Yes, Your Honor, for the merits, let me try to distinguish this situation from Lamon. In Lamon, it was 2, I believe that they were married, and they filed, it was a defamation lawsuit, and they filed 2 separate notices of, or 2 separate motions for disqualification. In this situation, that was at common law, the defamation. This case is a statutory right. It's a remedial statute, Your Honor. Each of my clients, Mr. Hupy, Mr. Cortland, and Mr. Green, have a remedial right in order to have their case before this court. They also have a due process right, which isn't available in a defamation case. So there's a heightened standard here. And so my clients would argue on the merits of this that the Lamon court did make a ruling that plaintiffs do not have a right to multiple disqualifications, but that does not extend to this factual situation. The clear language of the Public Records Act says that any person has a right to make a claim. And then if any person has a right to make a claim, then each Mr. Hupy, Mr. Cortland, and Mr. Green have a statutory right, an independent statutory right, because this isn't a common law right. They have an independent statutory right under due process in order to disqualify a judge. I'm sorry.
This isn't a common law right. They have an independent.
This isn't a common law right. They have an independent right under the Public Records Act and through the 14th Amendment of the United States Constitution in due process in order to disqualify a judge under that statute.
And Mr. Thomas, is there any case that you are aware of in the state of Washington that stands for the proposition you just outlined in regards to the operation of RCW 412050?
No, Your Honor, there's no case on point for supporting what I'm stating. However, Marine Power Equipment versus the Department of Transportation, a Supreme Court case from 1984, admittedly 4 years earlier than the Lamont case, they allowed a co-defendant to come on into the case and to file a notice of prejudice after substantive rulings had already occurred, because that was the first opportunity that the co-defendant had in order to file a motion for prejudice against the judge. And so they do break out co-defendants in previous cases in Washington State, which is part of the basis, and like I said, it's not on point, but it's part of the basis for why I think under a statute such as the Public Records Act that gives any person the right to sue, it would allow any person the right to disqualify a judge under that statute.
Thank you, Mr. Thomas. Well, the situation in this particular case is there was a complaint for a violation of the Public Records Act that was filed April 9 of 2018. It was Brian Cortland, Brian Green, and is it Hupy?
Yes.
And Christopher Hupy. And they had filed action together as plaintiffs versus Lewis County. Then there was on April 25th, 2018, a motion of prejudice, which of course the attorneys are aware these are now referred to as notices of disqualification. But pursuant to RCW 4.12050, that was asking that this case, that Judge Dixon not be allowed to hear the case. And that was based upon a declaration filed by Mr. Cortland. And then the case was reassigned on April 26th, I believe, to Judge Schaller. And then there was on May 16 of 2018, there was a declaration of prejudice, again, perhaps not correctly titled, but again referencing RCW 4.12050, and this was attempting to remove Judge Schaller from the case, and that was based upon information from Mr. Hupy. The matter then was reassigned to myself on May 17th, and the case was reassigned from Judge Schaller to myself, and that occurred. And on that May 17 date, a PRA status hearing was set for May 25th, which is today's date. So procedurally, I think Lewis County correctly, once they filed their answer, which was May 21st, they filed an objection at the first available time they could, based upon this issue of a limitation on the right of a multiple co-plaintiffs from filing multiple notices of disqualification. And the Lamont v. Butler case is quite clear in this court's view, and I find it persuasive. And so I'm going to deny that notice of disqualification and reassign the case back to Judge Schaller. There will be a PRA scheduling conference on June 8th at 9 a.m. And basically what I'm finding is that second attempt to disqualify was invalid. And that's the order I'm going to sign, but I would be willing to hear any points of clarification that you might have, Mr. Thomas, and then I'll pose the same question to Mr. Eisenberg.
Then plaintiffs would request costs and attorney's fees for having to come today. Two of the plaintiffs in this case are indigent, and this was untimely, and this could have been corrected at an earlier time so that we didn't have to come into court.
Well, that's not before this court today. Based on the procedural record I'm seeing, I'm not certain. Of course, if you bring a request, I would consider it, but I'm not going to wade into that issue today. Mr. Eisenberg?
Thank you, Your Honor. And I'm very sorry, but I have 2 hearings set in Lewis County on June 8th, and I'm not going to be able to make it. I wondered if we could do June 15th instead.
Could you look at Judge Schaller's schedule for June 15th? Mr. Thomas, would you be available June 15th?
Your Honor, we would prefer June 1st if possible. This case has been going on since April, and Lewis County it was actually served to Lewis County back in January. And this case is finally just getting around to a PRA hearing, and we would prefer the earliest possible one that we could get.
What's June 1st look like? I don't think Judge Schaller's here. Yeah. So Judge Schaller is not here June 1st. There is availability on June 15th.
Okay, we agree to June 15th.
Then I will make that correction to June 15th. That'll be 9 a.m. And I've provided that to the clerk. I think that's all for today. Thank you.
Thank you, Your Honor.
Your Honor, I wonder if I might be able to readdress the court on the matter. I tried to address it earlier at the end of the calendar today.
I honestly don't think that's going to be likely. As you heard, we have a matter that's going to take, first of all, I have another summary judgment motion. Then I have the case you heard about earlier, and I have inmate litigation that's hard set. The court also has ex parte at 1, and I have a Roush appeal at 1:30. So I think it's unlikely I'm going to have time until much later in the afternoon.
All right. May I address the court as to why I attempted to do it at 9 o'clock this morning, and then ask Your Honor as to whether there's direction about what I should do?
Mr. Eisenberg, I have no doubt that based on what I started to hear, that you're attempting to deal with things in an appropriate manner. But it's not ex parte, it's not been noted on this calendar, so no.
Thank you.
You're welcome.